Speaking of the upcoming Brussels decision, in just a week's time, the EU's High Court is highly expected to bar companies located in Jewish communities of the West Bank from labeling their products as made in Israel.
And many companies like the Psagot winery from Binyamin near Jerusalem are worried about the future of their business. Well, here now with more is founder and executive director of the Lawfare Project, Brooke Goldstein. Brooke, thanks for joining us.
Thank you for having me.
So why are how Israeli products labeled such a big issue today?
That's a really good question. Why are Israeli products being treated in a discriminatory fashion when there are several countries all over the world that the United Nations has deemed to be, illegally occupying areas? The United States and Puerto Rico, Russia, China, all these countries are engaged in human rights violations and occupying disputed territories, according to the United Nations, and they're not being given the same treatment. I think there's only one answer, and if you look at the definition, the IHRA definition of anti-Semitism, quote, applying a double standard by requiring of Israel a different behavior that's not expected or demanded of other nations, end quote, is indeed discriminatory anti-Semitic treatment. So we have to ask the EU, why are they treating Israeli products this way? And in fact, when you look at the the Advocate General's non-binding opinion, which was released, I think this past June, it expressly states that he recommends the EU treat Israeli, aka Jewish products differently. You label them as a product from an Israeli colony. He recommends you treat Jewish products differently than you treat Muslim products, aka Palestinian products coming from made in Palestine is the label that he wants. That is clearly discriminatory. So I really don't think that the European Court of Justice is going to follow this type of reasoning by the Advocate General. And I also have to say that there's been a lot of fake news and misrepresentations of factual issues, of legal issues that are being spread, unfortunately, to the media. And it's very, very questionable. And I think that Israeli people need to know what the facts are.
Well, obviously, we hope that the ruling will not be approved. However, should the EU approve the banning of labeling settlement goods as Israeli, what is the biggest damage that will come out of that ruling?
Especially for, local businesses like the Psagot winery.
There are two very specific questions before the European Court of Justice. Number one, does EU law mandate the labeling of Israeli products from so-called disputed territories as coming from, quote, Israeli colonies? And the second question is, if not, are EU member states free to impose their own labeling? Now, the facts are clear. There is no EU law that mandates products from Israeli producers in the disputed territories be labeled Israeli colony. There is a non-binding notice by the European Commission, and that is exactly what Psagot was challenging. Now, if Psagot had never brought the case, the status quo would remain. There would be a non-binding European Commission notice that is being treated as binding by countries like France, that is being implemented now by countries like Germany, by countries like Belgium. It is simply incorrect that this notice was not being applied. So if Psagot had just sat there and done nothing, as opposed to exercise its legitimate right to avail itself of a court system to argue against discrimination, Israeli companies would have been targeted. Now, even if there is an adverse ruling by the European Court of Justice this month, the EU Parliament and Council can still amend the food regulation at issue and annul it just like it did in the Western Sahara case.
Wow. All right. Well, Brooke, thank you so much for joining us with more information about this case. And we're just going to have to wait until next week to see what happens.
Thank you.
Thank you.